This is a video about the legal classifications of various different types of slip and fall or trip and fall type claims. Generally speaking, there are going to be three different classifications a person is going to have when they are on the property owned by another. And this is one of the initial legal hurdles we have to get over as attorneys in order to help our clients recover. The first classification is pretty simple, that of a trespasser. The duties owed to a trespasser are far less than the duties owed to other type of entrants. And so, generally speaking, trespassers don't have that many rights provided to them by the law because they're not supposed to be on the property to begin with. And therefore, the owners of the property don't owe as many duties to trespassers if that trespasser is injured while on the property of another. The biggest classification that we see and that we like to have our clients fall within is the invitee classification. In other words, this is an individual who is supposed to be on the property either by an express invitation, meaning please come into my business, or an implied invitation, meaning the invitation and your presence on the property is allowed by implication on the surrounding circumstances. That's going to be a very fact-specific issue. However, it's going to be one that has to be overcome and the box checked to make sure that we can get over that hurdle, because once we get over that hurdle, the landowner is going to owe invitees many more duties to protect against dangerous conditions, warn against dangerous conditions, maintain their property to prevent dangerous conditions. And so this classification is the one that we like to have our clients fall into. And think of perhaps going into a Publix supermarket or a Walmart to go shopping. That is an example of an invitee, a classic invitee scenario, because the public is invited in to shop. And so you're allowed to be there, and these landowners, whether it be a Publix or a Walmart, or whether it be a convenience store or some other facility where people are expected to be, those owners of property owe certain duties to the people that are coming onto their property, onto the premises, and those duties involve protecting people, invitees, from being injured on the property by a dangerous condition. And so those are the two big classifications. And then the lesser known classification besides trespasser and invitee is going to be a licensee. And the licensee classification falls between invitee and trespassers. And we don't see that too terribly often, but the idea behind a licensee is that the person may or may not be using the property for their own benefit, or there's a very specific reason why the person is using property, and if they're using it inconsistent with that specification, then they might be considered a licensee, and whether or not they're a licensee or a trespasser is a big question for the court to determine. So those are the hurdles we have to get over from a legal classification standpoint in every trip and fall case. And so it's imperative that you document and contact your attorneys immediately when something happens on the property of another, so we can solidify and lock in that classification. If you have any questions regarding these issues, please contact us immediately at our office.